Goeiedag, good day, fellow South Africans and citizens of the world. And you know what? Like American politics, South African politics is far from boring. Even though South African politics is just completely crazy. And it's an oxymoron because the guys running the country are so incompetent and they're so corrupt and there's absolutely no kind of checks and balances like they have in the US, where they have a Senate who kind of says, hey guys in the House, you did this wrong, you did that wrong, and you need to go and face a court or whatever. In South Africa, the parliamentarians are basically above the law. We all know that. It's self-evident. Now, this brings me to this stoush between the state president, one Cyril Ramaphosa, and the public protector, Busisiwe Mkhwebane. And they're both in two different factions of the ANC, and you can see what's going on. There's a huge, huge issue here. And now they're using different little levers to try and bring each other down. It's this is a very dangerous game, believe me. Public Protector Busisiwe Mkhwebane and her office will take the brunt of the storm after the apex court in the country on Monday morning delivered a critical and stringent judgment focused on her conduct in the contentious Bancorp ABSA report. Mkhwebane, the Public Protector, must personally pay 15% of the South African Reserve Bank's legal costs because she was biased and did not fully understand her constitutional duty to be impartial and to perform her functions without fear, favour or prejudice. A majority judgment written by Justices Sisi Kampepe and Leona Taron found. A dissenting view by Chief Justice Mogoneng and Acting Judge Patricia Goliath argued the personal punitive costs order must be set aside. You can see it's getting very interesting. It's going way beyond politics. It's now right up in the whole judicial system. The public protector's conduct in the High Court warranted a de bonis propis, personal cost order against her because she acted in bad faith and in a grossly unreasonable manner. The public protector's entire model of investigation was flawed. She was not honest about her engagement during the investigation. In addition, she failed to engage with the parties directly affected by her new remedial action before she published her final report. This type of conduct falls far short of the high standards required of her office, the judgment found. Now, who else did we have recently saying that? Oh, that's right. It was Hippo Eyes. Cyril Ramaphosa said exactly the same thing. She published her report without actually giving him the opportunity to go and review it and answer to it. Naughty girl. But then she is in Ace Magashula's camp, isn't she? And they want to nationalize the Reserve Bank of South Africa because there are lots of cookies they can get out of that one. Whew. Ooh. The question before the Constitutional Court was Mkhwebane's appeal against the personal cost order, as well as against the stinging paragraphs underlying this judgment written by a full bench in the High Court in Gauteng in 2018. The South African Reserve Bank's cross-appeal asking for a declarator stating Mkhwebane abused her office in conducting the Bancorp ABSA investigation was dismissed. Not because Mkhwebane was found not to have abused her office. The Constitutional Court said it couldn't make such a judgment because it didn't have the benefit of the merits underpinning the case. You gotta love South African judiciary, haven't you? I mean, really, I need someone to write a book about the judiciary in South Africa. Yeah. Forget about gangster state. Peter Myberg, you should be writing about the judiciary in South Africa. It is a hugely conflicted issue. Regardless, getting back to the article. Nevertheless, the ink wasn't yet dry on the judgment when non-profit organisation Accountability Now wrote to the Legal Practice Council asking that Mkhwebane be scrapped from the role as an advocate for lying to the court and having acted in bad faith, resulting in a serious credibility and integrity crisis for Mkhwebane and her office as public protector. Whew. Now you can see the politics coming in, can't you? The judgment also opened the door for a second cost order. In another case, DA versus Public Protector Mkhwebane's equally failed Estina report. Remember who was involved there? Yeah, Ace Magashula. See how the names come up? And the Guptas and the Zumas, the other faction away from Ramaphosa and Pravan Gordhan, who are kind of sitting in the other court and cowering because the Ace Magashulas have the upper hand at the moment. But this is where the judicial system is so conflicted. The High Court has been waiting for the Constitutional Court before deciding on whether it will afford another personal cost orders against Mkhwebane over the Estina report. Such an order now seems to be inevitable. On the political front, this is also a win for Mkhwebane's detractors. The pending review application of Minister of Public Enterprises Pravin Gordhan and President Cyril Ramaphosa would benefit from Mkhwebane already being found biased, unfair, and to not fully understand her constitutional duty to be impartial and to perform her functions without fear, favour, or prejudice. Speaking of a constitutional delinquent, Monday's judgment poses difficulty for the EFF too. Calling Gordhan a constitutional delinquent may have been fairly effective in a way that has slowly chipped away at Gordhan's credibility and that of the president. It is a tactic that worked very well on former President Jacob Zuma before, and one that Malema would know so well. The Apex Court has, however, now all but labelled Mkhwebane a constitutional delinquent. It matters because the EFF's tactics employed against Gordhan and Ramaphosa are mostly based on Mkhwebane's findings, and now they've been found to be flawed. The EFF also has a not small issue of its own. 16th of February 2018 statement. If this important office is to have integrity, it cannot be occupied by people who lie and are misleading, above all who are impartial and hell-bent on undermining the mandate of the office and the Constitution. And that word impartial is as it's written. And obviously it's totally in conflict with what they're trying to say. We call on her to step down with immediate effect. This judgment means she has failed in her duty. The DA's Muzi Imani, I'll get that name right sooner or later. It's Maymain. Okay. Maymain! May sit with a similar conundrum. He laid the complaint against Ramaphosa, but also wants Mkhwebane gone. Ramaphosa's weakened position is at this stage much dependent on the credibility of Mkhwebane. The DA will have to find a way to show that the allegations against Ramaphosa have their own legs, that Ramaphosa can be corrupt and Mkhwebane can be unfit for office, and that the two facts are not mutually exclusive. You see how interesting politics in South Africa is becoming? Because the whole system is so corrupted and so incompetent, it's like beeswax melting into a ball of nothingness. Mkhwebane attended the reading of the judgment and told journalists after proceedings that I never told any falsehoods. She knows quite well that she cannot appeal against the Apex Court judgment and didn't want to be pushed on the fact that she was found to have acted in bad faith. This is a far-reaching judgment that will negatively impact other public protectors, she said. Personal and punitive cost orders are extraordinary in nature and should not be awarded willy-nilly, the Constitutional Court said, but rather only in exceptional circumstances. The punitive cost mechanism exists to counteract reprehensible behavior on part of a litigant, i.e. Busisiwe. It means the conduct concerned is extraordinary and worthy of rebuke, just as Kampepe and Turon said. Mkhwebane, on the other hand, argued that she may have acted with unbridled zeal. Woo! Joan of Arc, here we come. On a charger. Oh my God, so many visions come into my head. Let's get back to the story. Mkhwebane said, on the other hand, she may have acted with unbridled zeal and said the recovery of public funds should be applauded, not met with punitive personal cost orders. The majority judgment disagreed, finding as follows. Regard must be had to the highest standard of conduct expected from public officials and the number of falsehoods that have been put forward by the public protector in the course of the litigation. The punitive aspects of the cost order therefore stands. Now, you've got to admit, the timing of this is quite extraordinary when you look at her claims against Ramaphosa. I mean, they are quite extraordinary. And this is where you've got the two factions of the ANC, which are like at war with each other. And they're using different arms of government right now to try and get the other ones out. It is quite extraordinary what's going on in South Africa. And you know what? All this is based on pre-1994 governance. Isn't that interesting? Here they're talking about decolonizing the schools, rewriting history, bringing Kiswahili in as the next language in South Africa. You know, the whole thing is ass about face. It was white colonization of South Africa that brought this country up to where it was in 1994. That was the only reason it got where it was. And it's taken only 25 years for these... Where's my little Pogmahorn? These Pogmahorn idiots to destroy what was once a beautiful and well-run country. Anyway, getting back to the story. The court has repeatedly affirmed the principle that a public official who acts in a representative capacity may be ordered to pay costs out of their own pockets in certain circumstances. Cost orders are not granted against public officials who conduct themselves appropriately. They are granted when public officials fall egregiously short of what is required of them. There can be no fear or danger of a personal cost award when a public official acts in accordance with the standard of conduct required by them by the law and the Constitution. The only relevant question, therefore, is whether the High Court was wrong in concluding that the public protector did not act in good faith and behaved in an unacceptable and secretive manner, just as Kampepe and Turon said. The majority judgment then continued to evaluate 6 points made in the High Court judgment in order to decide that the lower court came to the correct conclusion. 1. Immunity under Section 5.3 of the Public Protector Act. Mkhwebane said she is indemnified against personal cost orders by Section 5.3 of the Public Protector Act that says no member of the Public Protector's Office shall be liable when they acted in good faith. The Constitutional Court said that the High Court found that the public protector acted in bad faith. This court has no reason to interfere with that finding. 2. Sufficient opportunity be heard. Mkhwebane said the South African Reserve Bank did not properly ask for a personal cost order against her in its notice of motion, but only in its replying affidavit, and therefore the application was flawed. The Constitutional Court disagreed, saying this was not necessary. Mkhwebane knew that the personal cost order had been asked for and had an opportunity to defend herself. That was sufficient, Kampepe and Turon said. 3. Wrong principle of law. Mkhwebane argued that the High Court mistakenly conflated the principles of bias and to hear the other party, audi alteram partem. She argued that the High Court found she was biased because she did not afford the SARB and ABSA an equal opportunity to put their case forward after Mkhwebane met with then President Jacob Zuma and then Minister of State Security David Malobo. Mkhwebane says this was actually a question to be debated under the principle of hearing the other party, and therefore the High Court wrongly found bias on an Audi question. Justices Kampebe and Turon disagreed. 4. Misdirection of the facts. If the High Court made a mistake on the facts, it was to be grounds for an appeals court to interfere, Mkhwebane argued. However, the High Court held that Mkhwebane acted in bad faith, did not fully understand her constitutional duty to be impartial and perform her functions without fear, favour or prejudice, had failed to produce a full and complete record of the proceedings, and was not frank and candid with the court. Justices Kampepe and Turon said these findings are underpinned by various factual findings made by the High Court regarding the conduct of the public protector. And this is why I've been saying for weeks now, guys, that this public protector, this woman, is in the court of Ace Magashula, which is why nothing has ever been done about anything he's been involved in. But if Zuma puts one little foot out of step, it's the whole world falls down upon him. This is what's called bias, and it's rampant right throughout the legal system in South Africa. 5. Meetings with the presidency and state security. The public protector was obliged to provide a full and frank account of her conduct to the High Court, which had irked the SARB and ABSA. This included proper explanations about why she did not disclose meetings with the presidency and the State Security Agency in her final report, why she held meetings with them but did not afford the SARB and ABSA at the same time, why she discussed amending the Constitution to take away the central function of the SARB with the presidency and not with the SARB experts, why she discussed the vulnerability of the SARB with State Security Agency, and why she did not provide proper notes and transcriptions of these meetings to the court. She did not. The SARB was especially perturbed by a handwritten note posing the question, how are they vulnerable, in a discussion about the central bank with David Malobo, and interpreted this as an attack on the bank. Said the SARB in the argument, it is unclear on whether possible basis the vulnerability, and vulnerability to whom, of the Reserve Bank was relevant to the Public Protector's investigation into the CIEX report. Mkhwebane ignored the serious concern Justice Kampipi and Turon said, and her belated attempt at an explanation made no sense. And we can go on and we can go on and we can go on, but the bottom line is that this woman is incompetent. She's a BEE icon, representative of why South Africa is imploding at all levels, because BEE and Triple B, Double E has brought in people, because of the colour of their skin, who do not have the qualifications to do what they're doing. And when you sow into that the tribal bias that comes in, and her involvement with the Zumas and the Magashulas of the world, you can see why South Africa is completely cactus. Now please remember to subscribe to be kept informed, ring the bell for updates, and have a great day. Bye for now.